Thank you.
Item 6.
First of all, I'd like to begin with SB 1412 by accepting the committee's recommended amendments on pages 5 and 6 of the analysis, and again, thank the committee staff for their help. California State University, of course, has a critical role in preparing California's future workforce. SB 1412, sponsored by the CSU Board of Trustees, is a bill designed to address the system's critical infrastructure needs. Capital needs of CSU are substantial. Currently, it's estimated that CSU has more than $2 billion worth of deferred maintenance on existing infrastructure. This amount is projected to grow by approximately $150 million a year. And remember that deferred maintenance, by definition, is work that we intentionally set aside. Here are some of the impacts of deferring maintenance. Fresno State suffered from a 3-day power outage because of an antiquated and failed electrical system. Cal State LA had a chiller go out, forcing the campus to spend $150,000 per month until the problem could be fixed. San Francisco State had to close their science building 3 weeks before the start of a new semester, leaving students, faculty, and staff scrambling. CSU also outlines an additional need to renovate existing facilities or construct new facilities totaling approximately $6 billion so they can continue to serve students and faculty learning for the 21st century. In our budget 2 years ago, responsibility was shifted from the state to the CSU for the maintenance and construction of facilities at the California State University system. However, resources to support new capital outlay and infrastructure investments were not provided. This change left the CSU with few options to address their ongoing infrastructure concerns. The University of California has used investment income to fund these needs. Unlike the University of California, the CSU is limited to investing only in fixed income securities such as government bonds, which have very low rates of return. The proposal in this bill would allow the CSU to, like the UC, invest in equity mutual funds and real estate investment trusts, still relatively low risk investments, but investments that would allow modest investment earnings that could then be used to address infrastructure needs without having to spend operational funds. This is important because right now, if the CSU wants to address these infrastructure needs, they have to take money out of operational funds, which should be used to serve faculty, students, and staff's operational needs. The bill has no opposition, and with me here today to explain much better than the bill is Robert Eaton, the CSU Assistant Vice Chancellor for Finance, Treasury, and Risk Management, and Wes Larson, the Senior Legislative Director of the CSU Office of State Relations and Advocacy.
Good morning, Mr. Chair and members of the committee. SB 1412 is, after the budget, is the top priority of our Board of Trustees. We want to thank Senator Monning, or Senator, I saw you there, Senator Monning, Senator Block, for your leadership on this. I know some of you were in Senate Budget Committee last summer, and so we're finishing the efforts of seeking this authority from the budget process of last summer, which you wanted to have a conversation on the policy. We've been working in earnest with legislative staff, Department of Finance, and with the Treasurer's Office to gain their support. In fact, the amendments that you accepted, the amendments that we accepted into this bill are the amendments that the Treasurer asked to gain his support. This proposal will provide a revenue stream to help address the critical infrastructure needs and reduce the pressure on our operating funds that ultimately will help the CSU budget be used to support students, faculty, and staff. We have with us, as the Senator indicated, Robert Eaton, the Assistant Vice Chancellor for Finance, Treasury, and Risk Management, who will describe how we're striking a balance between accountability and transparency and seeking this investment authority. Robert?
Thank you, Wes. Thank you, Senator Block, for the introduction, and members of the committee, thank you for the opportunity to speak to you today on this legislation proposal. As the Senator outlined, there's a substantial issue facing the CSU with respect to its critical infrastructure backlog and the need to fund that and the lack of resources to fund that. And so this is a tool which will help the CSU meet its capital needs without asking the state for additional dollars. It makes better use and more efficient use of existing assets right now. What we propose to do is to take a portion, a small portion of our existing portfolio of investments and put those in additional types of investments. Right now we're limited to fixed income securities, and as we noted earlier, we're proposing to add to the list of investments in which we might make an investment equity securities, equity mutual funds registered with the SEC, Securities and Exchange Commission of the United States, as well as U.S. registered real estate investment trusts, and earn a modest amount. We estimate probably 3 to 5%, some 2 to 4% over the rate of inflation over time, and then use the earnings on those to address our capital needs. Will not be used for ongoing operations. So in order to mitigate some of the volatility that may be associated with these types of investments, we have the legislation has provisions built into it to help mitigate the volatility. First, the use of the new investment options will be phased in over time. This will allow state leaders and the public to be assured that the new authorities are being used in a measured, prudent way. So the limits will be $200 million for the first year, increasing by an additional $200 million for the next 2 years, so $400 and $600 million, and then capped at 30% of total investments thereafter. Second, governance and oversight will be enhanced. The legislation stipulates that the Board of Trustees of the California State University create an investment oversight committee, which will make recommendations to the board on investments and provide expertise on the use of the new investment authorities. Third, investment reporting will be enhanced. Quarterly reports will be made to the Board of Trustees and annual reports will be made to the legislature. And then fourth, as we've touched on earlier, the earnings, the extra earnings will be used only for one-time capital expenditures. They will not be used for ongoing operations, therefore insulating the ongoing operations of the California State University. So in summary, we think this is an opportunity to allow the CSU to make better use of existing resources to meet its capital needs without asking the state or students for those additional resources. But most importantly, it provides additional funds, or pardon me, it ensures that there's more operational dollars that will be available to faculty, staff, and students. With that, we respectfully request an aye vote on the matter. Thank you.
Thank you. Any others in support? Is there any opposition? Seeing none. Questions? Senator Monning and Senator Pan.
Thank you, Madam Chair. I want to thank the author for bringing this forward. It does seem well considered and in a prudent way to try to address ongoing needs of the university. I think you addressed some of this, but are there prohibited investments of junk bonds or speculative investment that is higher risk?
That's correct. The language specifies that the new investment options are mutual funds registered with the SEC, as I noted, real estate investment trusts. So that does not include junk bonds, hedge funds, commodities, those types of funds. So,
thank you. And you mentioned an advisory committee that would be established. Would that include members of the Board of Trustees of the university system?
Yes, what we envision is that the chair and the vice chair of the finance committee of the California State University Board of Trustees would be on that committee, as well as the CFO of the CSU. The majority of the committee, though, again, to kind of mitigate some of the volatility, will be comprised of members who are not employees of the CSU or affiliated with the CSU and who have investment expertise.
And are there conflict provisions in terms of an investment decision that could benefit, say, a board member who's not on that advisory committee?
As a normal course of matter, when all matters that come before the Board of Trustees are vetted for potential conflicts of interest. So that would fall under that protocol as well.
And then, thank you, that's helpful. And in the event of investments are made, there's a down market, maybe down for a while, hopefully nothing similar to what we faced in 2008, 2009, but by definition, markets climb and they fall.
Yes.
So you indicated that no operation funds would be put at risk, but in terms of capital improvement or investment in fiscal plant, how do you plan against the possibility that you don't return the investment that you seek?
Yeah, so one of the reasons we've emphasized one-time capital needs, for example, we won't debt finance and use this as a source of repayment. The one-time capital funding on an annual basis, we can notch that down and take it up if there are volatility, if there is volatility in the returns. And then also what we envision doing is on the returns that we do earn, we will take some of that portion and we will set it aside in kind of a rate stabilization fund. We'll kind of bank it there to help offset mitigation or ups and downs volatility in the returns in future years. And that way we can kind of, try to avoid large swings in the capital funding from year to year.
Those current reserves, out of which a designated percentage now would be available, does that in any way impede in those reserves funding that could currently be used for operational increases, for example, in faculty pay, that will now be taken off the table because they get designated only for this investment for one-time capital improvements?
And it should not have an impact on that. With the cap in the long run of 30%, that still leaves 70% of the total investment reserves that we have that would be continued to be invested under the current fixed income securities. And one of the reasons we've modeled that cap where we have is because what we have typically carried over year to year is well above that cap, so, or pardon me, well within that cap. So if there was some volatility in these new investments, the basic operations on an annual basis would not be affected. There's plenty of room there. And even on a multiple year basis, we would still have plenty of cushion in that sense. Also, I would add that a lot of, for example, you mentioned faculty salary, a lot of that comes out of the state general fund appropriation. That bucket of funds, if you will, is not part of this legislation. That continues to be held at the state level and invested and managed at the state level. It's not part of our portfolio.
Thank you. That's helpful. I appreciate the clarifications. Thank you.
Dr. Pan.
Thank you so very much. And I think I was at the budget hearing last year, and certainly I welcome the opportunity to actually diversify the portfolio to get a better return. I think the challenge is balancing, and many of my questions even last time was about, it's risk reward, right? We're going to seek a greater return from investing in our economy, and as that grows, but there's also the risk side, and I know that Senator Monty asked several questions, so I just wanted to, so I appreciate many of the elements in the bill, and thank you, Senator Block, for authoring it and the amendments that the committee is proposing. So just to clarify, in terms of, you talked about certainly one-time, capital pursuit. Are we looking at also maintenance as more of an ongoing thing? And there's a lot of deferred maintenance on Sac State, which is the campus in my district. Are we looking at maintenance, which is more of an ongoing issue, although there are obviously, you retrofit a whole building or something, but how does maintenance fit into this versus new capital expenditures in terms of the use of these funds?
Right. Generally speaking, maintenance is an ongoing type of expenditure if it's planned out appropriately and would not necessarily be covered here. But as you can appreciate, over time, if there's lack of funds to do that, then that's when it becomes deferred maintenance, right? So again, if the opportunity with one-time funds is there to address a critical infrastructure deferred maintenance need, we will do so. I mean, that's part of the opportunity here that we're seeking. So,
but the plan is for ongoing maintenance. That really should be kind of
more from ongoing operations. Yes. Yeah.
All right. That's good to know. And then the other question I have, because I know that Senator Monty asked about junk bonds. Now, I know you're restricting yourselves to essentially licensed mutual funds and retirement trusts. I would also note, though, is that you can buy a mutual fund that's one sector, that's junk bonds or whatever. I don't think we want to try to micromanage all of that here at the legislature, but and actually one can argue there may even be a place in a diversified portfolio for what we call high return bonds. But in terms of that restriction, I just want to clarify, because you did say that we're not putting, so what's the scope of the mutual funds? I'm not looking at trying to put something in the legislation, but how do you see in terms of the portfolio management, in terms of because there are a wide scope of different mutual funds. I mean, we're not talking about hedge funds or anything, but even within the mutual fund world.
That's one of the reasons why, I outline kind of the target return. If you introduce, as an extreme example, a junk bond portfolio, then there is much more significant volatility in your return profile than, say, 3 to 5% or a couple of percent over the rate of inflation. So, and, even though we've got a lot of language in here that mitigates some of the volatility and protects taxpayers and students, absent the language of the legislation, the CSU is very mindful of our mission and, the operational need and the service of the students, and we're not here to put that in jeopardy. What we're looking at is to try to get a modest additional return so we actually help students in the long run by addressing capital needs in the facilities. So it's not our intent to introduce that kind of volatility. That's one reason why we agreed to a mutual fund structure as opposed to direct investment. So that's some of the considerations, perhaps in response to your question.
And then finally, to clarify, I know Senator Monty asked about the investment committee in terms of the trustees themselves, but in terms of the members of the investment committees themselves, I know it's going to be a challenge. You want people with expertise in investments. At the same time, they probably have that expertise because they're known in the field, but we also, in terms of the conflict issues for people who are on the investment committee actually advising the board of trustees on the investment strategy.
Right. So as part of the protocol, conflict of interest protocol I mentioned, what we have done, we've actually already initiated this. The first stop with respect to this investment expertise is to actually go out to our foundation boards. Each of the 23 campuses have those. They have a lot of local expertise, individuals with investment knowledge, and so we want to go there and tap the existing resource because our endowments, by and large, have been very successful with a broader array of portfolios. So those individuals are familiar with the types of conflict of interest protocols and background. That's where we're going to go first, and as I indicated, that's our standard, and we expect to keep to that standard.
And certainly, I hope the names of the people who are on the investment advisory board is available for public.
Yeah, I mean, it will be part of the board of trustees presentations and minutes and that kind of stuff. Yeah.
All right. Thank you so much.
Thank you. Okay, we've been joined by
Alan Gordon. I'm a deputy treasurer in the office of State Treasurer John Chung, and we're here very happily to support the bill and want to thank Senator Block and the folks at CSU. When they first came to us with the original version of this bill about a year and a half ago, we had some pretty serious concerns, and much to their credit, and I think ours, we've worked very closely with them over the past year and believe they've really put together a good piece of legislation right now. I know, Senator Pan, you were in the committee last year, and I would say all of the concerns that we had have been taken care of. The investment committee, we think, was very important. The guardrails that have been put around the investments are excellent. I apologize we didn't get a letter in time. We have spoken to Ms. Scherer. I had a very lengthy conversation while we were traveling back east and voiced our support at that point in time, and we'll have a letter very shortly. So with that, Treasurer Chung would like to thank all of you and ask you to support the bill. Thank you.
I'll move the bill.
Thank you. The bill has been moved. Any other discussion? Would you like to close, Senator Block?
I'll adopt the Treasurer of the State of California's words as my close.
Thank you. Okay, the bill has been moved. Let's call the roll.
Item number 6, SB 1412, do pass as amended to appropriations. Liu.
Aye.
Liu, aye. Block.
Aye.
Block, aye. Hancock.
Aye.
Hancock, aye. Huff. Leyva. Leyva, aye. Mendoza. Monning. Aye. Monning, aye. Pan. Aye. Pan, aye. Vidak. Aye. Vidak, aye. 7.
7, the bill has sufficient numbers for passage, but we'll keep the roll open for our absent members. Thank you. And you have one more bill, item 10, SB 1439.
Thank you, Madam Chair. Thank you, gentlemen. Third part of the trilogy. SB 1439 provides an additional tool for the California community colleges and the California State University system to use in their efforts to provide a workplace and educational institution free from sexual harassment. The measure would require that an applicant for an academic or administrative position at the community colleges or at the CSU disclose any findings that have previously been rendered against him or her that the applicant committed an act of sexual harassment. There's an illustrative story I'll tell in a little bit about a gentleman who was hired at CSU after he had a previous finding of sexual harassment against him. He didn't disclose that, and there's frankly nowhere on the application that would have required him to disclose that. So we're trying to fix what's basically a loophole there. Additionally, it would require the community colleges to consider any known finding of sexual harassment when determining whether to continue employment for a contract employee who is up for a reappointment. As we've seen recently, sexual harassment can have a devastating toll in the educational setting. Last month, most of you are familiar with the fact that the dean of the Boalt Law School at Berkeley was forced to step down from dean when it became public that he had been disciplined for sexual harassment. Previously, a prominent astronomy professor at UC Berkeley resigned. This was in 2015 after a 6-month investigation found that he had sexually harassed several students dating all the way back to 2001. Again, in both these cases, if these people were to apply now for other positions at other universities under this law, if it's CSU or community colleges, they would be required to reveal, disclose past findings of sexual harassment. At San Diego State University, and this is the most on point of the cases, a professor was accused and confirmed to have sexually harassed up to 4 female students. He was suspended for 30 days before finally resigning. The 30-day suspension seems to be wholly inadequate. Much better way to deal with this would be to know up front, and frankly, much more protection for the female students, would be if the professor never got the job at San Diego State to begin with. In the arbitrator's decision affirming the suspension, the arbitrator found that the professor had previously been accused of sexual harassment at the University of Delaware in 2011. He soon resigned from the University of Delaware and applied at San Diego State, where he was appointed with tenure because he had the requisite years, and then he resumed the same behavior at San Diego State. In the decision of July 2015, the arbitrator commented, given his previous experience at the University of Denver, Professor Martin should have redoubled his efforts at professionalism. Instead, within a few months of his arrival at SDSU, strikingly similar behavior emerged. I'm not so concerned with what Professor Martin should have done. I'm concerned with what the university should have done. And because we can't depend, obviously, as in this case, on the professor changing his or her behavior. In this case, the university should have known that he had committed these acts in the past, but they were, there was nothing on the CSU application that gave them that knowledge. Obviously, had they known of the professor's conduct at the University of Delaware, San Diego State, the CSU would never have hired this professor. Sexual harassment is obviously devastating to victims. It creates a workplace and results, it creates a havoc in the workplace and results in students often turning away from a field in which they wish to study because they want to avoid the abuser. Particularly in small departments, my experience at San Diego State was that students would in fact leave a major, leave a graduate program even, because they knew that in a small department they would have to take 1 or more courses with the abuser, even after there might have been a finding of sexual harassment, because a finding sometimes results only in a suspension and not in dismissal of the faculty member. Clearly, we need to do more in this area. This measure is just one step to help weed out candidates for positions who have a history of sexual harassment. Bill has no opposition. I ask for your aye vote.
Thank you very much. Anyone in support of the bill? Is there any opposition to the bill? No tweeners today. Oh, sorry.
Andrew Martinez, California State University. We don't have a position on the measure at this point. We are willing to work with the author and look at the issue. Obviously, sexual harassment, sexual assault is a serious issue for the institution. We have bent over backwards to be in compliance with all of the Clery Act, all of the state laws, And with the recent state audit report, we have implemented all of the findings that were suggested to us by the auditor. So we continue to work on this matter and take it seriously, and would like to work with the author in the next committee.
Thank you. Okay, questions, Senator Vidak and Senator Monning.
So this is going to be like a checkbox on an application? And if yes, please explain, or?
It would be up to the CSU or the individual community college districts to determine how to gather this information. It would require them to gather the information, and then it would be up to them to decide how to act on that.
They can't do it now? I guess, I mean, they.
Well, they can do it now. I don't think there's any restriction on them doing it now. But as the gentleman from CSU just stated, they follow all the laws and requirements and do a very good job of that. This isn't a law requirement. After the governor signs this bill, it will be, and they will follow this.
Thanks.
Okay, Senator Monning.
Thank you. Again, I want to thank the author for bringing this forward. I think it's pretty clear, but just to be absolutely clear, the inquiry would be as to a finding, some legal determination that the person has been found guilty of sexual harassment.
That's correct. The applicant would not be bound to disclose unproven allegations, but merely those where there have been findings.
And then is the bill silent as to if the person does check that box, does it create an automatic bar to hiring, or is it just a factor that you want the hiring committee to be aware of? And you can answer that, but then could a university or a community college, with that knowledge, how could they complete a hiring of that candidate and without facing potential huge liability? I'm not arguing that they should hire that person. I'm just wondering, does that end the application process?
It would certainly be at their peril if they hired someone who checked off that box, if there is a box on the application. Hopefully they would not hire someone with that in their background. And by the way, this also requires the person to disclose, which the person is not required under law now to disclose sexual harassment. Since it's not on the application, they don't have it. That's important because if an applicant doesn't disclose, and let's say as the gentleman from San Diego State came in as a tenured professor, the harassment he then committed at San Diego State, apparently in the eyes of the arbiter, wasn't enough to cost him his job at San Diego State. It was merely a suspension. But lying in the interview process would be grounds for dismissal, notwithstanding his tenure.
Right, and it would also protect the university that they made the effort to determine any convictions or findings of sexual harassment. So if the person lied, if they were fraudulent in their application, it provides the employer some protection that, well, they committed fraud and didn't tell us this.
That's correct. And obviously, most importantly, it protects the students and other workers at the institution from a predator.
Which is the objective.
Absolutely.
Thank you very much.
Thank you.
Okay. Senator Leyva, welcome.
Thank you, Madam Chair. It's been a crazy day. So I have to admit, Senator Block, when I first read the bill, I thought you were asking the sexual harasser to check it off him or herself, and I thought, I don't know if that'll work. But on reading it again, I now understand that they would have to check that off. And I just want to say thank you for doing that, because I think what happens a lot of times with people who are chronic sexual harassers is they just move from one job to another until they get found out. So hopefully this will stem that within the UC system. So thank you very much.
Thank you, Senator.
CSU, right.
I never correct someone who's about to vote on one of my bills.
I'm just curious, do we know of any other higher ed institution that does this?
We don't know. We haven't looked into that outside the state of California. But it wouldn't be a bad thing to look into.
Okay.
Yeah, we would recommend that the UC do this. Of course, we can't force them to do it. And frankly, if no other state does it yet, all the better. We're the trendsetter.
Right. And I know this bill has been double referred, so the next committee will talk about the confidentiality of the information, et cetera. So with that, is there a motion? The bill has been moved. Okay, closing remarks?
Just ask for your aye vote.
Thank you.
This is item number 10, SB 1439, due pass to judiciary. Lou? Lou, aye. Block?
Aye.
Block, aye. Hancock?
Aye.
Hancock, aye. Huff? Leyva? Leyva, aye. Mendoza? Mendoza, aye. Monning? Monning, aye. Pan? Pan, aye. Vidak? Vidak, aye. That's 8-0.
8-0, okay. Sufficient for passage. We'll keep the roll open for an absent member. All right, Senator Mendoza. Last bill of the day, item 8, SB 1420.
Thank you, Madam Chair, members. I'm here to present SB 1420, which is a vital bill to protect the health and safety of early educators who do tough and sometimes literally backbreaking work of caring for young learners ages 0 to 5. This bill requires all licensed caregivers for children to complete a one-time training on occupational health and safety risks specific to the child care profession and on how to identify and avoid those types of risks. This bill also requires that the Department of Education to develop the curriculum for the training in consultation with the State Department of Public Health and also compensate the caregiver for attending these trainings. Child care providers have high levels of on-the-job injuries. This is critical. This is a critical concern for our state. A study after study documents that child care quality is the most dependent on child care staff working with children. If a child care worker is injured, child care quality is likely to decrease. Anyone who has a toddler knows how easy it is to throw out your back picking up a 30-pound child, especially when he or she is kicking and squirming. With that, Madam Chair, for the sake of time, I'll just be brief and let my sponsors speak.
Michelle Castro, the Service Employees International Union. We are the sponsors of this bill. We have been working with the various agencies, CDE, Department of Social Services, Department of Industrial Relations, to make sure we get this bill right. I'm going to defer the rest of my time to Tanya McMillan, who's our witness. Thank you.
Okay, thank you.
Thank you for inviting me here so I can speak to you today. Like she said, my name is Tanya McMillan, and I am a family child care provider from the city of Bellflower. I am also the co-chair of Raising California Together, a coalition of child care advocates, and I am the treasurer and a proud member of SEIU Local 99. I have been a child care provider now for 22 years. A few years ago, I strained my back picking up an infant in my child care. You don't realize how much pain you're in until you strain or injure your back. And you can't imagine how I felt not being able to bend down and tie a child's shoe or pick up an infant to put her in her high chair just because of the pain that I was dealing with at the time. Singing, playing, and teaching my daily curriculum is excruciating when you're in pain. But the worst part of it all is at the end of the day, I wasn't able to give each child a hug as they were going home. When I was injured, I was lucky to be able to keep working, even though every step was painful. But I worry about slipping or tripping, which could put me in a position where I could not work to this day. Beyond strains to muscles, we spend 10 or more hours each day. I personally work 13 hours every day around young children who are amazingly cute, but they have a whole lot of germs that older kids and adults do not have. Their germs, to me, are worth it, but it's still a hazard to the job that I'm doing, especially when I'm left deciding on what kind of cleaning materials to use that can have toxic side effects on myself. Finally, dealing with stress is a major part of my job. I have stress about keeping the children in my care safe and stress about ensuring I'm meeting each family and each child's needs to develop and thrive. And that's on good days. Unfortunately, due to the haphazard way that our child care system works, many times I also have stress worrying whether my low pay will cover all my bills or whether my pay will even arrive on time. Child care providers don't get sick days. We can't leave the children in our care to keep running to the doctor. To do our jobs, we have to stay healthy and we have to stay injury-free. I am proud and grateful that Senator Mendoza, who is my senator, I live in his district, is putting forward this bill. SB 1420 will give child care providers and center workers the opportunity for training that can help us take care of ourselves and in turn care for the young bodies and minds that are in our care. More than 95% of child care workers are women. So this bill is important both in delivering training, but also delivering dignity and respect in the important work that I have been doing for 22 years and other providers like myself. Whether we work in a child care center or operate a daycare in our home, our work is vital to the families we serve, and we are the critical link to learning California helping disadvantaged children succeed in school. But our jobs haven't been treated in that way. Those of us who work in our homes earn just 1/3 of California's new minimum wage. We don't have workers' compensation insurance or the other protections California has championed for wage earners because we are considered employees of no one. Your vote will help us do the child care jobs California is counting on and send a signal that California is standing up for child care workers who are vital to our future. And thank you for allowing me this opportunity to share this with you.
Thank you. In support?
Dion Arier on behalf of SEIU. I'm just here to provide technical assistance and answer any questions you might have.
Thank you. Okay. Any others in support?
Michael Young on behalf of the California Labor Federation, also here in support.
Thank you. Okay. Any others in support? Any opposition? The committee didn't receive any opposition. Any questions from members? Comments? Senator
I would simply move the bill. I think this is a really good bill, and the more help and support we can give our child care providers, the better.
Thank you. Okay. The bill has been moved. No other comment? Would you like to close?
Madam Chair, members, please respectfully ask for a vote. Thank you.
Thank you. Okay, let's call the roll.
Item number 8, SB 1420. Motion is due pass to health. Liu?
Aye.
Liu, aye. Block? Aye. Block, aye. Hancock? Aye. Hancock, aye. Huff? Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. Monning? Aye. Monning, aye. Pan? Aye. Pan, aye. Vidak? No. Vidak, no.
Okay.
7-1.
7-1. You have sufficient votes for passage. We'll leave the roll open for our absent member. Do we know if Senator Huff is going to return? Okay, let's open the roll for absent members to review the activities for the day. Let's just start with number 1, SB 884. Bell.
Okay, item 1, SB 884. Motion is due pass as amended. The vote is 5-0. Chair voting aye. Block? Block, aye. Hancock? Aye. Hancock, aye. Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. That's 9.
9-0, the bill is out.
Consent.
Item 2 is consent, SB 893.
I'm sorry, 5-0, chair voting aye. Hancock? Aye. Hancock, aye. Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. Monning? Monning, aye. That's 9-0.
9-0, the bill is out. Item 3, SB 1113, Bell.
The motion is due pass to health. The vote is 5-1, chair voting aye. Hancock? Aye. Hancock, aye. Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. That's 8-1.
8-1, that bill is out. Senator, item 4, SB 1146, Laura.
The motion is due pass to judiciary. The vote is 3-2, the chair voting aye. Hancock? Aye. Hancock, aye. Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. Monning? Aye. Monning, aye. That's 7-2.
7-2, sufficient for passage. That bill is out. Item 5, SB 1359 block.
The motion is due pass as amended to appropriations. The vote is 5-0. Lou?
Aye.
Lou, aye. Huff?
Aye.
Huff, aye. Leyva? Leyva, aye. Mendoza? Mendoza, aye. That's 9.
9-0, that bill is out. Item 6, SB 1412 block.
The motion is due pass as amended to appropriations. The vote is 7-0. Chair voting aye. Huff?
Aye.
Huff, aye. Mendoza? Mendoza, aye. 9.
9-0, that bill is out. Item 7, SB 1417 Galgiani.
The motion is due pass to appropriations. The vote is 2-1. Lou?
Voting.
Hancock? Hancock, aye. Huff? Leyva? Leyva, aye. Mendoza? Monning?
I'm voting aye, but I wasn't here at the time of the presentation, and just for the record, I have some reservations. I'm going to follow this and reserve my rights down the road. Thank you.
Okay. Thank you.
5-1. Oh. Mendoza, aye.
Same comments.
Mr. Monning.
That's 6-1.
6-1, that bill is out.
I think that we all have the same, probably the same comments, but it will move forward for right now.
Bill is moving forward. Okay, 6-1, was it 6-1?
Yes. Yes.
Okay, item 8, SB 1420 Mendoza.
The motion is due pass to health. The vote is 7-1. The chair voting aye. Huff? No. Huff, no. 7-2.
7-2, that bill is out. Item 9, SB 1432 Huff.
The motion is due pass as amended to appropriations. The vote is 7-0. The chair voting aye. Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. 9-0.
9-0, the bill is out. And item 10, SB 1439 block.
Sorry. The vote is 8-0. The chair voting aye. Huff? Huff, aye. That's 9-0.
9-0, the bill is out. Thank you very much, members. The meeting is adjourned.